Is someone you love detained in a care home or hospital against their wishes? Do you want to challenge this, but you don't know if you can afford to? In my previous videos in this series, I talked about how you can challenge someone's deprivation of liberty under a standard authorisation in the Court of Protection when that person lacks the capacity to make a decision about where they should be staying themselves. In this video, I will look at how you can fund that challenge with legal aid. My name is Olivia Allen and I work in the Court of Protection Department at GN Law. So, how can you fund your challenge to someone's standard authorisation? As this area of law concerns someone being deprived of their liberty, potentially against their wishes, legal aid is available to challenge it. This means that the government will pay for your legal fees if you're eligible. Importantly, this legal aid could be non-means tested, which means that you would not have to earn under a certain threshold in order to be eligible, but that you could get legal aid regardless of what you earn, however high or low. However, please note that you can only get non-means tested legal aid if you're the detained person themselves, i.e. the person who lacks capacity, or their relevant person's representative, their RPR. If you're not the detained person or their RPR, then you'll only be eligible for means-tested legal aid. This means that you'll have to meet certain income and capital thresholds. For example, you will not be able to get full legal aid cover if you earn above £733 of disposable income per month and have £8,000 in capital. But remember, if you're receiving a passporting benefit, for example, income-related support, then you will not have to satisfy the income threshold, though you would still have to satisfy the capital threshold. Now, whether you can get non-means tested or means tested legal aid, in both cases, you will also have to satisfy a merits threshold. This means that your case will need valid grounds to be brought. In other words, a 60 to 80% chance of success. But don't worry, this element is quite easy to show. Depriving someone of their liberty is a serious matter, and it will almost always be in someone's best interests to check that this deprivation is lawful, particularly if they're objecting to their placement. You should now have an idea of if you can get legal aid funding in order to challenge someone's deprivation of liberty under a standard authorisation in the Court of Protection. But finally, please note that the Deprivation of Liberty Safeguard Scheme will be changing in October 2020, and we have other videos on the new scheme which you may find helpful. If you need help and advice on this or any other Court of Protection matter, call me today on 0208 492 2290. And if you found this video helpful, please share it.